Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions in the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. On this show, I interview lawyers ditching the billable hour and experts who can help attorneys move beyond billing time. Thanks to my sponsors, 650 and Gavel. Links to both in the show notes. More on them later, and use the code LAWSUBSCRIBED when signing up. You get 10% off, and it supports the show. The best way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. I'm thrilled to have with me here today on the Law Subscribed podcast just another person cut from the same cloth, fellow warrior against the billable hour, John Chisholm. Welcome to the show.
Oh, thank you, Matthew. It's great to be part of it. I've watched some of your episodes, and some of my friends, Ron Baker and Tom Bowden and Matthew Burgess and Scott Lee, they've all been on your show. So I feel very privileged to be asked to join the likes of people like them, giants in the value-based pricing and subscription model world.
And also one more person who's been on my show. I see their book in the background. It's Sean Hardeen, right?
Yeah.
So his episode isn't live at the time of recording, but yet there's another person. So I'm the one who's the fortunate one, because now I feel like I've been led into this circle of incredible people trying to end the billable hour. So I feel like I'm the fortunate one to get to talk to all of you folks. And my audience is probably already like, all right, we're slowing this down from 2x speed to 1x speed, because of all those people that you just mentioned as well. Like there's so much wisdom that you have to give to our listeners today that I'm so glad to have you here. And it might even just be the experiences from other people, but that's still wisdom, John, and that still counts. So then, just in case, just like I'm just discovering everything that you've been putting out there, even though you've been around with the other folks that you just mentioned, in case my audience hasn't come across anything that you've done yet, just give yourself a little introduction.
Well, I used to say I was a recovering lawyer. I'm actually recovered. I think I have after 20. It's been 20 years since I've actually run or been in a law firm. So I was third generation lawyer. My grandfather, I joined what was partly the family firm. I was articled to my father. And so I joined the law in the late 1970s, not 1870s. And sort of I did bit of everything. You could do it in those days, property law, commercial law. I had one family law file, and I think the world is a better place that I only ever had one family law file. And I was managing partner for that firm for 8 or 9 years. And then I moved to another firm as chief executive for 4 or 5 years. And then at the end of 2004, I don't know whether I spat out or spat myself out of the system. I was cooked, Matthew, and my wife and I took off in 2005 and drove around Australia for 4 or 5 months. And perhaps it was up to me, I'd still be doing that. It was just a great way of getting back together again. And the last thing I ever thought of at that time was have anything to do with the law. But here I am. I've been consulting now for nearly 20 years, and I love it. And one of the best things was meeting the likes of, the Ron Bakers of the world. Sad to say that was after I finished mainstream law. So I'm much more innovative and less risk averse now. I don't run a law firm, Matthew. So I'll be quite upfront about that.
Well, you got out and recovered lawyer. I think that's the first time I've heard that. That's a good one. You made it. Just had Scott Simmons on the show, and of course,
Scott.
So okay, Scott. So I don't know, when these episodes are going to air, but he said he hates that term, recovering lawyer, right? So that's his perspective on that. But we talk about that on his episode. But a recovered lawyer, that's a good one. I got to ask, because we don't just want to assume here, but I got to imagine when you were practicing law, you were billing your time.
Well, yes, but I'm old enough. I turned 70 this year. I'm old enough to remember when I started law, there wasn't time-based billing. I didn't, of course, we billed clients, but there was no such thing, or at least in our firm, of time-based billing. And in fact, it's really interesting when I look back and I think how I was taught as a young junior lawyer and those in the firm about how to bill files. My father, who was the equivalent of managing partner, senior partner at the time, I think every Thursday morning would have a pile of files on his desk, and he would just go through them, and he would ring up the client and say, "Well, Mr. Smith, Don Chisholm here. So, we finished your matter. How do you think we went? You're happy, da, da, da." And if Mr. Smith said, "Yes, you did a great job," he said, "Oh, I'm so pleased to hear that, because we put our best and brightest on your file. And, but, this is what the price is going to, be, or the fee's going to be." And so he did the fee and already got agreement from the client, then sent out the bill. Occasionally he would ring up and say, "Oh, Mr. Smith, it's Don Chisholm here. And, how did we go? And a little bit unhappy, Mr. Chisholm, because your son hasn't returned my phone call," or whatever it was. And if the client, he would sort of in his mind, "Well, we'll reduce the price, we'll give you a discount." But up until he practiced law till he was 92 years of age, and he passed away 3 years ago, Matthew, he always rang a client before he sent out a bill. Now, I don't care if you don't do anything else. I mean, it sounds so basic, doesn't it? But he always got agreement before, he never billed by time, never filled out a timesheet in his life. But yeah, and I think that's something that if we, even as lawyers, if we did that, we'd be better off as a profession, because there'd be no such thing as bill short. So yeah, but I think I was pretty shy at filling out timesheets, quite frankly. That's probably why the firm made me managing partner, because I could make everyone else in the firm fill out timesheets and I didn't have to.
So that I actually want to tug on that thread, because here's the thing. Like, what I find a through line, in particular from the lawyers that have ditched the billable hour and are using an alternative business model, is that they were always better at business than they were at just like filling out timesheets. Like, they were always better. And there's something there, right? There's got to be something there where if you have something, I don't know if you're born with it or your life has exposed you to something different, that you see that there's a better way. And like it's like Socrates said, to know the good is to do the good, right? And there's there's multiple ways. It's philosophy to look at that. But one of the ways that you could look at that is just knowing the good is good enough. You're not actually doing anything. But the other side is, to know the good is to do the good, means once you know a better way or you see the flaws in a thing, you can't possibly do anything other than the good. Or you can't possibly do the bad because you know the good. And so I wonder if there's something there that we were never good at filling out timesheets, because we just, some part of us knew that there was a better way. What do you think?
Well, I look, when you think about it, I mean, as an infant, as a child, as growing up, the world has prices. I mean, we buy and sell everything, so there's prices. And then we get into a law firm, and all of a sudden there's no such thing as price. It's quite weird. It's all about, rates, hourly rates. So it's quite foreign now. That's the way we're taught when we actually get into the law firm. And I did. We made the transition in the early 80s, and I was one of the young Turk partners, and, convincing firstly the older partners, which included my father, that we should introduce time recording. And I can still remember the partners meeting and my father and the other senior partner saying, "So this is not to bill clients." And I'm going, "Well, no, father, this is just so we can find out who the lazy lawyers are in the office and those that aren't, doing any work." And then that was the second biggest lie I told my father. And 2 weeks later, we're, got hourly rates because we copy all the other firms and we're doing it. And look, it's a profitable business model. I understand that. And I hear what you're saying. I'd love to say I was smart enough to think that there was a better way. I didn't like it. I think it's an unnatural, I mean, apart from the fact it's, inaccurate and non-transparent, but it's just a bizarre, we pretend we picked the best and the brightest out of law school, and what do? Make them account for every 6 minutes of their day. It's just dumb. Most other industries aren't like that. But look, it was, and look, I suppose one of the things I didn't like, and there were several things as managing partner, as CEO, is that awful situation where you had, a dissatisfied client, and often I was called in to sort of be or John, you've got some rapport with people. Can you sort this out with the client? And it's an awful situation to be in, not just for the client, but for the firm. I'd have the client saying, I was told it's going to be $10,000 and the bill's $50,000. And you had partner sitting there going, well, John, I did the time. So, where do you go? And usually there's a compromise if you want to keep the client, all that sort of stuff. If you couldn't explain to them why it was justified, the bill shock. Sadly, I have to tell you, if time was written off, it was probably written off from a junior lawyer's rather than the partner, because why that is. So look, it had a lot, but I didn't. Of course we had some fixed fees and those sorts of things, but mostly it was the time-based billing model, and I wasn't either courageous enough or smart enough or hadn't met, until I left law firm and I went to a conference in Sydney the end of 2005 and heard someone speak. He was an accountant from part of the Veris Age Institute, which I didn't know about at that time. A guy called Paul O'Byrne, and I heard him talk about value-based pricing, and it was my aha moment. I mean, he was an accountant talking about his accounting firm, how they not only don't record time, but they don't bill by time, how they became more profitable, how great for culture, all that sort of stuff. I was like a fanboy. This was in Sydney. He'd come from the UK that weekend. I followed Paul around asking him all these questions, and I think just to get rid of me, he said, look, next time you're over in London, come and visit me. Like I go to London every week. But 2 weeks later, I got on a plane and went over and spent a couple of weeks with Paul and his family and his firm and his clients. And I thought, wow, this is absolutely fantastic. What a great business model. If accountants can do it, surely lawyers can do it. So came back to Australia and brought Paul out to Australia several times, touring with firms, and they all said, wow, that is so interesting. Don't ring us, we'll ring you. And then sadly, Paul passed away in 2008, but through Paul, I met Ron Baker, and, the rest is history, as they say. And I think, as I may have said to you, I just can't believe in 2024, we're still talking about, getting rid of the billable hour. In my wildest dreams back 20 years ago, I didn't think, I thought so much else in the world has changed that certainly we changed the billing model in law firms. But no, it's still predominant. I think it's sick. I think it's dying, but it's still around.
I'm just coming off a conference, ABA Tech Show in Chicago.
Yes,
and
saw that. Congratulations.
Yes, thank you. And so one of my presentations was with another warrior against the billable hour. I think she's still recovering attorney, Stephanie Everett of Lawyerists. And we were doing a panel on Gen AI is going to be the thing that finally ends the billable hour, whether you like it or not. I know Ron's got opinions on that, and
Yes.
we'll hear yours in a minute. But like in that, and like in that group, in that the attendance, which I think it was like almost every single seat was filled. So we're talking about like 60 to 70 attorneys in the room. And one of the attorneys said, well, like we have all these KPIs, these key performance indicators around time metrics. And like, so I hear what you're saying, and we could start doing these other things, but shouldn't we still be keeping track of our time? Because the KPIs are about time. And it becomes like the inverse relationship. Like, sure, maybe you want to track your time in the beginning, but like eventually you're going to want to be spending as little time as possible on every single thing to still get the same result. Does it make sense to track your time anymore? No, but still. And this was, by the way, a young attorney. This was a young attorney who had her own firm, and it was like a 10-attorney firm. But, a young attorney still. Billable hour, KPIs, sunk cost fallacies. So it's a problem. So what are your thoughts on that?
Yeah, well, look, we've done a great sell job on ourselves and on our clients, quite frankly. But as I said earlier on, it's such an artificial and just bizarre way. And I get it all the time. Blame the system. I'd love to change, but this, we're bought a practice management system that has time. Our KPIs are around time. Who's running the show? Some inanimate object, or you people as partners and owners of the business? So that's just a cop out. Or the other one is it's the clients. The clients want it, and she will do anything that clients want. More BS. But yeah, look, I mean, there are some firms. I mean, ideally, I'd say come Monday, get rid of your timesheets and we'll start value pricing. Now, for most firms, they'd probably go backwards because we're not good at pricing or espousing the true value that we should to our clients. I understand that. So most of the firms that I've worked with over the years have kept their timesheets and time recording, at least for a while until they get more confident and competent in understanding the true value they're providing and in their pricing. And then the timesheets become redundant. But in the smaller firms, my experience, and this may not be yours, most of the lawyers are pretty, don't like filling out timesheets anyway. It's pretty off and on sort of stuff. Whereas, in big law, or I call it old law. I think big law is just a nice way of saying old law. It's just, we call it new law, but they don't want to call it old law. But that's firms that leverage people by time by hourly rate. And, it's just into the firm right from the beginning. If you want to succeed in this firm, whatever else you're good at, you have to excel at recording your time. And it's just such BS. But, most of them, and if you speak, and I don't remember if you've asked this question on your podcast or not, Matthew, but most of the firms that I've worked with, if they say and have made the transition to a timeless environment, if they had their time again, they would have got rid of their timesheets earlier. But sometimes you can't because they've got, contracts, with clients that run on. But yeah, and look, I think we're smart people. If the world outlawed time-based billing on Monday, what firms would survive? They would, and I think the profession and their clients would be better off for it. But it is what we've got. I do understand that, but yeah, it's just got to change, and it will change whether I'm still around to see it. I don't like the term alternative fee arrangements because I don't want it to be alternative. I want the billable hour to be the alternative, if anything. But so,
I'd not want it to be alternative. I would want it to be dead and gone for the billable hour.
Exactly. Right. Exactly. And look, I think you mentioned about Gen AI, and I don't, is that going to kill the billable hour? And I think it should hurry up the demise. But gee, there's been so much other factors to, client dissatisfaction, the wellness of our people and ourselves, and a whole range of other things. Still hasn't killed it. I think though, all these, it's like a pincer movement, all these things together will certainly make it happen quicker. And again, if you want some controversy, I think it's kept alive just by lawyers, both lawyers who sell time and lawyers who buy time. It's, at the big end of town, the clients are really lawyers themselves, and it's what they understand. And unfortunately, for much of the profession, at least in the past, we've seen what a global law firm does or a big law firm do, and we try and imitate them. And, if it's good enough for them to keep billing by time, then we think it's good enough for us. But most of the firms that I've worked with are smaller firms, partly because it's easier to get change management done in a smaller environment, but also it differentiates themselves. And, I think it's just talking with a firm yesterday, and, for them to be able to say to their clients or the market at large, you will never, ever receive a bill from our firm that you have not pre-authorized. It's worth its weight in gold in terms of, marketing and PR out there.
Even better if that approval is before the work even starts.
Sure.
Right? Like, let alone that, I had Sean on the podcast, and he was doing like a combination of good, better, best pricing with value-based pricing. So like what's traditionally maybe with subscription pricing, but for a single project, here's, price A, B, and C before the project even begins. And that Like one of them is I'm going to give you the quickest turnaround humanly possible, but it's also going to be 10x what the other
Yeah.
thing's going to be. And so you're going to be happy because it's a boatload of money. And your client's going to be happy because it's turning around really fast if that's the one that they choose. And so I think you can. I think there's all these different ways that you can approach it where even with a lot of unknowns, I think if you just assume the worst and price it accordingly, I feel like you could get a price up front.
Yeah, and it doesn't always have to be a price for the whole, the whole shebang right to the end. A lot of the firms I work with, particularly in litigation, they do phased or milestone pricing, and if the scope changes. Now, the problem with lawyers, we think, change of scope is I spend an extra 6 minutes on a phone or whatever. So, oh, the scope's changed, so we have to reprice it. I mean, that's just, that's billable hours in drag. But, smart lawyers mostly know generally what's going to happen, unless it's something that's substantially out of scope. But we just have to get rid of this time. Once you've scoped it, priced it, just get on and do the work. And sure, we've got to do it well, but the quicker we can do it, the quicker the turnaround for the client. I think if our clients are at all interested in time, it's elapsed time, turnaround time. How long is it going to take you, for me to get what you've told me I'm getting? Not how much time I'm spending in it, but when am I going to get it? Am I going to get it tomorrow? Am I going to get it? And if you can use Gen AI or any other legal tech, or you just happen to have the smartest lawyers in the world, great. But that's back end stuff as far as I'm concerned. It's the outcome and the output, the results to your clients that we need to focus on
Right.
much more.
Right. And, my perspective on the whole Gen AI thing, on how that's finally going to be the thing that ends it. I agree with you. It's a pincer move. Like there's so many things coming together, but I think like the largest frontal attack is coming in with Gen AI. Just because it's just so less profitable now than previously. Like it's been more profitable for a long time to not bill your time, especially as technology has gotten better. But with Gen AI, and this is part of what we talked about in the presentation, is if a 10-hour task takes you 2 minutes, that takes 10.0 to 0.2. And if you were billing $500 an hour, it's a 5,000% increase to your bill to bill the same amount. And at least I think most legal ethics in most jurisdictions, a $25,000 an hour rate is probably unethical. It's probably not reasonable. And so like the legal ethics combined with the profitability of there's better business models than there have ever been before. I feel like now is definitely the time. If there's ever been another time, and there will still be laggards, but I feel like we're going to start to see far more attorneys looking for the other solution, especially when they see their time that they're able to bill just disappear. Unless they start taking on boatloads of new clients, which there's only so many who are willing to pay hourly rates in the first place.
And Matthew, you've read this and seen that. I see what I call the old law prices or billers or whatever saying, well, how are you going to price Gen AI? And what they're saying is, well, that's going to be for lower level, value stuff that, we never really made money out of. Well, that's BS because they have a leverage model like that anyway. And it means it'll free up all our time because we can do the high value stuff. So, and we'll charge out incredibly hourly rates because that's what the clients will appreciate. So, I mean, it just doesn't make sense. Every lawyer thinks they're doing this incredible high value bet farm stuff. It's just not the reality of the world. And, again, if you want to pay me $25,000 for a result and I can get that result in 5 minutes, we're two consenting adults or whatever, and provided you've got the results and you're deliriously happy, I don't need some ethics bar or whatever to tell me and I should have, build the time out of that. It's just rubbish, but it's it's that vicious circle we've got ourselves. And you look at other industries, you look at how the whole world works, the entrepreneurs, it's just so the antithesis. It's not, I can't imagine Steve Jobs ever filled out a timesheet. It looked pretty shit probably too.
I want to touch on another thing that you said. And that is how lawyers don't just sell time, we buy time. But I think more and more, now than ever, every lawyer probably out there has at least one subscription. They probably have at least five. And that includes business and personal, right? So, like, this is a model. If you think about the cream rises to the top, the subscription business model is the most pervasive business model that we're exposed to these days. So, like, if they just stopped for 2 seconds and thought about this thing they're paying for on a subscription and how they could apply it for their own business, they'd realize how much of an expert they kind of already are, because they're very, especially with the law firms that are subscribing to services and software. I mean, they are discerning buyers. So they
Yep.
think about, how much am I paying every month? What are my subscription benefits? Am I getting am I maximizing my benefits? Is it worth it? Like, I'm sure they're thinking about this stuff. They just never have turned it around and applied it to their own business model, right?
Yeah, absolutely. We're not talking about common sense or anything here. Yeah, when you think about it, in a big firm that has their KPIs and I'm measured and reward on my billable hours or the fees that I make and all that sort of stuff. So, and that determines in a differential profit share how much I'm going to take home. What's in it for me to come up with a subscription model that's going to benefit the firm, but not perhaps me as individually as one of 120 or 250 partners? So I think that's, talking about the, the system which we've put in place, doesn't encourage that. But you're right. And firms, to be fair, most firms have some retainer type of arrangement with clients, but retainers are usually limited by hours or, particular area of work or what have you. It's not such a big leap if you can get over all the inbuilt obstacles to turn a retainer into a, subscription model. And you're right, we subscribe, like Ron Baker and all the others, but we subscribe to everything these days. Why? Or, to say, but the legal profession is so different from every other industry in the world, it makes no sense. And I think it's better. It can be more profitable for the law firms and more profitable for the clients. Plus, I can't talk about the multiples in the US, what someone would buy another firm for, but certainly here, in Australasia, firms struggle, partners struggle to get a multiple of even more than one on one or whatever if they want to sell their practice. And it's because we really don't have, recurring income stream. And you look at those businesses that, have 8, 10, 15, 20, 25 multiples. Most of them is because they've either come up with some brilliant proprietary, product or system or process, or they've got this recurring income stream that we haven't. And I think those, certainly the ones that I work with that are on a subscription model, they see the recurring income stream as a great benefit for them down the track.
So you asked a really good question, and it was a little bit rhetorical, but I'm going to ask it again, and then we'll talk about it. And that was, you're this hypothetical attorney. Why come up with a subscription model that benefits the firm but not me? I mean, I'm abbreviating the question, but it's a really good question. And this is another thing that I've been spouting as an inevitable future because of Gen AI and the subscription model, and that is the fall of the big law firm, maybe even the mid-sized law firm, because the subscription model and all this technology that automates a virtual law firm, and it's cheaper than ever to have a law firm and start one. You could get to good profitability with a virtual automated practice on your own. I'm living proof. And so am I ever going to make the stupid millions of dollars doing what I'm doing that I'd make at a big law firm? No. But do I need that money, and would it make me happy? I don't think so. But even for some lawyers, if you want to take a premium approach, now I'm targeting an untapped market, the latent legal market, but even if you wanted to do a premium pricing subscription approach, you could still make incredibly good money. It's not going to be in the stupid amount of money. And you don't really need big law anymore. What do you think?
Okay, so I've been on the record saying this, probably why I don't get invited to many legal conferences anymore. I I think there will always be a place for lawyers in the world. I don't think there'll always be a place for law firms, particularly big law. I've always said that. And I think partly for the reasons you've said, but also, big law's a 20th century invention, and it was built on the leverage model and all that sort of stuff. Now, if you've got all these factors that are destroying the leverage model because I don't need that, but I can get it in technology, Gen AI, or however I can get it, it doesn't make a lot of sense. Plus, I think as lawyers, really what we are is that we're consultants as lawyers. Okay, we have a law degree and what have you. And more, I think, just as we're using Gen AI, so are other professionals, so are other businesses, so are our clients and what have you. So I think the world, clients can get the same, if not better benefits, or they will in the future, by not necessarily going to a law firm. The kudos of big law and whatever, I think will eventually eat itself up. I think part of the, and don't get me wrong, of course there are some changes, but the incremental changes, I think big law has always put, because of the model that they implemented, and I did, the firms that I ran, it put the performance of an individual over the performance of a firm. I don't care what they say that's what it did. And that, I think, and you look at even other consulting practices, major consulting practices that have a reputation and a brand, I probably couldn't pick out an individual, partner or owner or director of those firms, but I know the brand. Whereas mostly big law, it's an individual partner's personal brand because that's how they get money. It's also they can move around and shop there, take their practice with them, those sort of things. So I just think it will come to an end at some stage. And you're right. I mean, people like yourself and others, as with a young lawyer, there's not when I first started practicing, Matthew, there really wasn't it. You either went to the bar, we have a separate bar here to be a, barrister and counsel, or you joined a law firm. Maybe you could go into, government and work there. The really, in-house was just starting to, get bigger. Now there's so many opportunities for those that have a law degree, but they're far more than going into a private law firm. They seriously are. And I just think some stage it'll all come tumbling down. I also think that at some stage, whether it's one of the global law firms or one of the big four, or someone will, the penny will drop and they'll change their business model. And as we've seen what's happened before, you wait, all the lemmings will start to follow. So hope I'm around to see that.
When I went solo, I pivoted from mostly litigation to a transactional-only practice. I did not have a database of documents to automate. That's why a business and employment legal document database and automation tool like 650 is super useful. I can rely on the quality of the documents in 650's database since they're putting excellent legal minds to work curating and updating their documents and automations over time. When you're not billing by the hour, outsourcing and efficiency matters, and 650 can help you scale your practice to get high-quality documents drafted in less time. Use the code LAWSUBSCRIBED at 650.com and when being onboarded to get 10% off. If you're not a business and employment attorney or you have your own documents that you'd prefer to use, then my next sponsor, Gavel, is the automation tool for you. Gavel allows you to build shareable, client-facing workflow and document automations. In other words, Gavel helps you create a legal practice where attorneys can monetize the value they bring clients in productized form and scale via subscriptions and flat fees. Use the code LAWSUBSCRIBED at gavel.io to get 10% off an annual subscription. There's no one right way to automate and scale your practice, but with one or both of my sponsors, 650 and Gavel, you can take your subscription law firm to the next level. Links to both in the show notes. Now back to the show. I think you will be. I think this is going to happen sooner rather than later. In particular, because, and I am now talking to operations folks at some big law firms because they've discovered the podcast, and they're like, well, what are we going to do? Because I'm telling them how, like, when their associates figure out that, like, for $5,000, they could have their own virtual law firm and be making six figures and actually, helping people then they're thinking like, what am I doing here in big law? They're going to have a labor shortage. They're going to have a problem. And I think we will see that. And I think the law firms will adapt, the big law firms will adapt as a result of there's already an insufficient amount of attorneys in the market that are, quote unquote qualified for big law, right? Let alone lawyers in general, at least in the US. I'm more familiar with the US market. And the section of legal education, the accrediting body for law schools in the US, is considering accreditation of all online law schools without a brick and mortar presence for the very first time. Now, that could increase
Yeah.
the supply of attorneys when you decrease the cost of putting on a school, so you could decrease the cost of providing someone with a legal education. But I still don't think that's going to be enough to solve that problem. But even more than that, I mean, if you have thoughts on that, you could share them. But I do have a question for you. So do you have thoughts on that?
No, I just think it's interesting. And the firms that I work with have gone to a subscription model or a value-based pricing model. Forget about the pricing side, which I think is wonderful. But just what it does is open up a whole new world of how they operate, how they create value for their clients, how they have better relationships with their clients, how they have a genuinely collaborative model internally or relationship internally. But we move away from, the attorney is the fee earner. I mean, fee earner, I hate that terminology, and in those firms, either no one's a fee earner or everyone's a fee earner. Everyone's got the client's interest at heart. Everyone wants, sure, we want to get the highest price if we can, but that's only because if we're providing, the best value. But I think we've just got to get away from the law is for lawyers, and both internally and externally. And
That is a
we've
perfect
got away with it for so long.
That is a perfect segue back into my question that I was going to ask you, because I want to talk about the monopoly on legal services. At least I'm not sure how it is in Australia. I know in UK it's been deregulated so that non-law firms can practice or do some things around like legal services. But in the US, other than Arizona and Utah, lawyers still have a monopoly on legal services. And so I do wonder if it's the fact that we just don't have competition, that there's been no
It,
incentive to innovate. What do you
it's
think?
absolutely the case. I mean, we it's not completely deregulated, but 20 years ago or whatever in Australia, so you can have profit sharing with, and again another terrible word, not non-lawyers. And firstly, 40 years ago, conveyances in the market when I first started, monopoly on buying and selling a house, you had to use a lawyer, and it was going to be the end of the world. No one else could do that, and so you have licensed conveyances here, and we've had our ups and downs with listed law firms here. But I think the point is that if you're involved in law, you've still got responsibilities to, at least in our case, to the court system and those priorities. So it doesn't mean all of a sudden it's an open slather. And when I was in the US a few times talking about opening deregulating the market, I had people standing up at conferences, Matthew, going, well, that just means they're all they're going to be doing is, after $1 and ethics is going to go out the window, as though we're holier than thou and are not chasing the dollar ourselves. Of course. And, good organizations, whether law firms or whatever, have got to make a profit. But certainly there's been no, and I read with interest some of the comments there that, and I just think, sorry, I go at your colleagues, but it's being propped up because they want a monopoly and it's protecting themselves. It's not protecting the consumer. It's not protecting clients whatsoever. And you can still have protections and open it for, in inverted commas, non-lawyers. And, apart from other things, access to better funding, those sorts of things. And I think it has an impact on access to justice. It continues to make law, the gap between those that should have access to lawyers and don't is just widening. It's not lessening in our world, unfortunately.
And that's just simple. That's just the law of large numbers and population growth, right? The population grows faster than the amount of credentialed attorneys that we could have, certainly, right?
But
And more people, more problems.
If I could, whether it's Gen AI or whatever, and I can get something done for cheaper, still make a profit out of it, I can service. If I want to service And we all know that there are too many people in our community that don't have access to justice. We can do that. The reason why, I mean, I know law firms have pro bono and that sort of stuff, but it still means, unfortunately, that so much of our population, at least in Australia, and I suspect it's the US, just doesn't have access. And it's because for law firms, I can't make a profit going into that area. Well, if you can't, let those that can go in and service those not as privileged as we are.
I think you can make a profit. Not billing your time, you can make a profit, but subscription, you especially can make a profit, but you don't make a profit in, quote, access to justice. And here's why. Because for access to justice, you still have to wait until there's a problem.
Yeah.
And at that point, it does, the unpredictability meter starts to go up. And things will only get more expensive once there's a problem. If you get it before there's a problem, before they even need access to justice, then you can make a massive profit because you're helping, but it has to be at scale, and it has to be a low amount that you're offering, right? Like this is where, and I'm experimenting, mind you. This is where I think the $20 a month thing, like people balk at that I'm starting my subscription at $20 a month. But I'll tell you what, I had a client reach out to me. I'll give this example, and I'm not giving any names or areas or type of medical practice or whatever, but I do represent some physicians from time to time. And I have a couple who are still subscribed at this moment. And I won't tell you if this is one of my current subscribing physicians or a previous one, but when they were moving from one medical practice to another medical practice, part of what I was doing for them is I wasn't just helping them understand the contract for the new employment opportunity, but I was also helping them understand their compliance requirements with the past employment contract that I wasn't around to help negotiate. And one of those requirements was a non-solicitation clause. And of course, this physician is not going to solicit. But as I know, having represented physicians previously, that sometimes patients follow the doctor and you're not soliciting them. And so they're still in compliance. But I just raised that as a flag to the physician. And then several months into the new job, some past patients reached out to the physician. And so they reached out to me, and I drafted for them an acknowledgement that this physician did not solicit them, that they found the physician and came of their own accord because it was within the non-solicitation period. So the physician knew to reach out to me so that they could talk to me about this potential problem that wasn't a problem yet, and I could help them even further prepare a defense to avoid a future problem. And I know physicians are relatively privileged compared to like everyday people, but this is still a client who is paying $20 a month and $50 a page. Now, physician employment agreements are tens of pages, so it was very profitable for me. But that's an example of problem avoidance without even ever having a problem. One more example. Sorry, John.
No.
I'll let you talk, but I just got to give one more example.
I'm not.
For an everyday person, $20 a month, $50 a page. This person's been taking their dog to this groomer to get groomed for the last 10 years, like the whole life of the dog. They've been going to the same groomer. Well, one day, that dog groomer slid over a one-page contract, which was mostly waivers, for the client to sign, for my client to sign. And so the client, since they're a subscriber at $20 a month, instead of signing that waiver, well, it was a contract, but it amounted to a waiver. And they said, I'm going to come back later after I talk to my attorney about this. Now, I don't think anyone else at any other customer at that dog shop, the dog groomer shop, ever said that. So they sent me the one-page contract, $50. It's a no-brainer for them to have their lawyer look over it. I basically told them, don't sign this because you're going to give up your opportunity to sue if they hurt your dog. So I told them, I said, they still want your business. Go there and say, I'm happy to drop off my dog. I'm not signing that contract. And that's what they did. And their dog got their hair cut, and they continue to go there without being under that contract. But what would have happened? I don't know if this happened, but what would have happened if their dog got hurt? Well, now they're SOL, right? But not anymore. So there wasn't access to justice in either of those two situations. We avoided the need for justice in the first place. And I think that's the power of the subscription. And literally every person and literally every business is a potential client for that situation.
Yeah. So here, and I'm going to be aging myself, and I'm sorry, but if I look back, and remember I said that big law is a 20th century, mid 20th century, invention. When you think, if you go back to, at least when my grandfather was practicing, start of the 20th century and through there, almost the role of the local solicitor, the local lawyer, was almost a cradle to the grave type thing. A bit like the local physician that you were talking about, that sort of thing. So they were always there. They were, perhaps true trusted advisor, that sort of thing. And, my father did the same thing. Now, I think the subscription model could be the 21st century, sort of that cradle to the grave. You could theoretically, sign up, you whatever from as an infant, and you got the subscription model going through the whole way, so that I'm covered. It's like an insurance. It's like whatever. I'm covered, but I have a relationship with my lawyer. And to be honest, Matthew, despite the fact that big law talk about relationships and all those sort of things, I think, and Ron Baker would have spoken about this, and this thing about subscription models is it enhances the relationship with your client, and you need that relationship. You need to keep building on adding to the value that you're giving to your clients. I think most big lawyers don't want relationships. They want transactions. They're scared of relationships. No, I really do. They're scared of relationships. I'll talk about it, and I know, for marketing purposes, that sort of thing. But no, what they want is just the thrill of the chase, the transaction, move it on, go to the next thing. And that's another impediment to some of the big firms having a subscription model, is they really don't want a genuine relationship with their clients that you need under a subscription model, I think. And, I think, some lawyers I speak to, I have relationships at home or with my family or, my football club or something like that. Last thing I really want is a relationship at my law firm. I like transactions. I really do. And I don't know. I'd be interested in what you think about that.
So I don't know how I feel about that. So maybe you know different lawyers than I know.
So let me put it this way. I
Yeah.
think under a subscription model, having a relationship requires an emotional opening for the lawyer. I know we've got to be objective and we've got all those ethical situations, but I know many lawyers that would prefer not to go down that track and just, love the transactions and all. So I guess that's what I'm saying. But
so I do. I think I agree with you in part. So essentially, like, lawyers have low EQ, like low emotional intelligence, right? Which is true, but I don't necessarily think that just because they have low EQ doesn't mean they wouldn't find that they thrive if they tried with an ongoing relationship. And here's why I think that. When I was part of the time when I was the liaison to the young lawyer liaison to the section of legal education for the ABA, that accrediting body for law schools. There was our director at the time, when I was first doing it, was a man named Barry Currier. In Barry's opinion, and he was staff for the ABA, but he was also dean for a time of an all-online law school, and I think assistant dean at some other law schools and in faculty. And so he was very steeped in legal education. And, he talked about how, we are the one profession where most professors are not trained educators. Now, that could lead to bad results, and it does, but it doesn't most of the time, because in his opinion, and I agree with him, most lawyers, he thought all lawyers, there's always exceptions, but he said all lawyers are teachers. Like, we all are good teachers at the end of the day, because what is it that we're trying to do, right? We're trying to teach our client about the law applied to their facts for their situation, or teach the judge or teach the jury. Like, so much of what we do comes down to applying our expertise, our subject matter expertise, and then teach it to somebody, even if it's opposing counsel. So I feel like when you're on when you have this ongoing relationship, there's that student-teacher relationship, there's that mentor-mentee relationship, but it's attorney-client, and it totally changes the dynamic. That even though low EQ lawyers in that situation, I think they would end up thriving because of that. What do you think?
Yep. Look, I guess what I should say is that I think the big law, old law business model leaches a lot of that out of us the authenticity, all that sort of thing. So I guess I should, qualify by saying that, my partners had a white line fever. They were, terrific family people at home and wonderful people. They get to the firm and they're totally switched on, in their litigator mode and, aggressive and all that sort of stuff. And I think that's part of, perhaps it's what being a lawyer for some of them is all about, but I think it's the business model. Last week, I had a fairly senior lawyer in a firm. She came and rang me up about something, and we got talking about if she's unhappy with her firm and, competitive marketplace. And she said to me, John, the competition out there externally is nothing compared to the competition internally. That's why I want to leave. The competition for clients, the competition for work, competition for getting is much more than the competition outside the law firm trying to get new clients or new work. And that's pretty sad, isn't it? I think as a profession, and I think, it's right to say the system does it to us, but again, I get back to, we built the system. We brought the billable hour to the marketplace, to the clients, and I think we can take it away if we're courageous enough to do it, and we really want to do it.
I mean, that's a great bookend to the conversation. I don't think we could get better than that. But I just want to check to make sure, see if you have any more, if you have a few more minutes, because we're at time. I have a few more minutes if you have a few more minutes. Otherwise, I'll wrap us up.
No, well, I mean, I just, want to say genuinely, again, it's all right for me to, and I'm not a great pricer, and I'm not at the coalface. I think what I tend to do, my sort of why is to influence motivated professionals to make a difference. And I think, if I've been able to influence or open people's minds to, they can come up with, the different options. They can come up with the different models for their, subscription pricing or their value-based pricing and all that sort of stuff. So, and despite me, you may think I'm pessimistic about the profession, it's just so exciting what's happening down there. It's happening at the small end of town in terms of numbers, but that's fine. We don't have to, imitate big law. What big law do they do well? You take your Matthew Burgess, he says, he would have told you, look at big law and do the opposite. And he's been incredibly successful doing the opposite. And I think for many law firms, so for lawyers, for true authenticity, they should more look at doing the opposite to what perhaps they're being, taught to do, or what big law does. And they'll be better off. The profession will be better off. Our clients will be better off. And our people, our future lawyers will be better off.
Fantastic. I mean, I think I agree. I agree with all that. So with that, then, I don't think we actually ever said what you do, John. So how about you just let my listeners know what it is that you actually do? Because we've talked a little bit around it, but I don't think you actually said what you do.
Okay. So look, I run a consulting practice. It's a small, particularly these days. I did a sea change, my wife and I, about 6 or 7 years ago. We live down the coast now. I don't know whether you know where Victoria is or Melbourne is. So basically the most south of the mainland, then there's the island of Tasmania, and then there's Antarctica. So we're down that end. It's fantastic. I can swim in the ocean every morning. So I look after, a handful of clients, mainly in the pricing side of things these days. But the pricing, just going to upfront pricing, getting rid of the billable hour, getting rid of the time recording, just opens up a whole new world. And for me, that's more exciting for the firms than just the pricing side of things. And I think, at least the ones that I've worked with, and I know better culture. And I know that, old law say there's some great culture there, but I think that's more the exception than the rule. And so, so I look after some firms here in Australia, still a couple in the US and the UK. And it still is exciting to see the changes, even with the Gen AI. I don't pretend to be at the coalface, but I can see it's having an impact. And for those smart, courageous lawyers, they can make the most out of that, be better off, for them and their clients by embracing it. And I sort of look at the subscription model as at the moment, Matthew, as being a bit like Gen AI. It's the first generation, and it's the first generation of the subscription model, even though some have been doing it for 10 years. It's still, and, I think if we look at what Mark 2, Mark 3, Mark 4, Mark 5 of Gen AI will be, and we look at what Mark 2, 3, or 5 of subscription model, it'll be totally different. And
Yeah.
again, I hope I'm around to see it. We'll look back and say, how did we ever practice in any other way?
Well, here's hoping that the exponential growth curve on all those things just continues to take off, right? And then you'll definitely be around to see it. For those of my listeners who stuck through the whole episode, I just want to give one more tidbit is in the show notes. I'll be linking to an article that John wrote back on September 27th, 2021. It's a short article. It'll only take you 6 minutes to read it. But in here, I can't believe I didn't find this when I was originally doing research for this article, but in here are like so many first of all, I've interviewed a lot of the people that you reference in this article now, with Tien being like on my list of that would be a great get to get Tien. But like even you start with Mark Stiving, who I've had on the podcast and has had a big impact on the way I think about pricing.
He's great. That impact pricing, I love. No,
yeah. And Counsel for Creators, Kim Bennett is on here. View Legal, Elevate Legal. So, it was the article was prescient, and not a little bit before I was launching my own subscription law practice. So it's really something, and I highly recommend everybody check it out.
And you mentioned the Time's Up. Well, I don't know if you have it, but there's Time's Up, Ron Baker and Paul Dunn's book. So being a senior fellow at the Veris age, you can imagine Ron had been talking about subscription pricing well before the book release. So I have to get credit for Ron on that. And look, Ron's so far ahead of the rest of the curve, the rest of us. So he's going, it's going to be the thing of the future. Sure, Ron, it is, but you look, even the names in those articles, how I've updated it now. There's so many more like yourself and others, and the ones you've interviewed that could be added to that. So it is happening, and the profession is better for it worldwide. So thank you, Matthew.
Well, thank you, John. And, I have to ask you the question I ask all my guests, which is a hot dog a sandwich, and why?
A hot dog a sandwich? I don't eat hot dogs. Yeah, I should have been ready for that, shouldn't I? No, well, a sandwich, I think you cut all the way through. Hot dog, you don't, do you? You just open one part, or that just shows you my ignorance of hot dogs, I suppose. If I have to go out and buy one, and then I'll come back to you and take that on notice and answer that question, Matthew.
So I want to make sure what we're getting at least a little bit of an answer from you. I'm hearing no, because a sandwich is something you could cut all the way through, and not a hot dog. Is that your final answer?
Yeah.
Okay.
Yeah.
The only time I think I'd ever seen a hot dog like maybe cut in half, though, is for like if a kid was eating a hot dog and it was too much for their little hands to hold. That would be like the only time, but it's a different way that you'd cut through it. So it's interesting. Yeah,
that's true. Well, you're a practicing lawyer, so you will be able to come up with those sort of things to rebut my argument. I understand that. Yes.
I'm not saying that there is a right answer to this question. It's a great insight into our guests. So stick around if you can just for a minute, but we'll sign off. John, if anybody wanted to reach out to you or follow up, what's the best way for them to do that?
Yeah, so it's chisconsult.com or john@chisconsult.com.au. But I'm more than happy to talk to anyone about subscription models or value-based pricing. And, there's the world's our oyster, I think, is a profession moving away from the old law business model.
Well, that's it, John. Thanks so much for coming on the show.
Thanks for having me, Matthew.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn, since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.